Hi everyone, Louisiana Succession Attorney Brad Scott here. I want to talk to you today about a situation where you're opening an estate and some of the heirs may already passed away. What happens in that situation? Well, this is very common. Maybe you have a parent who's passed away, maybe they had a few kids, and maybe one child died before the parent, and then you had another child who died after the parent. The question always comes up with people who call and says, well, I'm the surviving heir, do I receive everything? Well, that's not quite how it works in Louisiana. And the basic rule you need to know is that pretty much everything kind of flows downhill, down the family tree, unless there's a last will and testament that states otherwise. So let me give you an example. Mom passes away and she had a child who died before her, but that child did have some children of their own, leaving some grandkids. And maybe there's 2 or 3 other kids who are alive from that mom. In that situation, the child who died before, predeceased the mother, that person's kids step into their place and become heirs of their grandmother directly. There's no need to do that child's succession who already passed away before the parent did. Now, on the other hand, if a child dies after the parent and we're opening the succession of the parent, the deal there is that that child was alive when the parent passed away, so they already vested with rights of inheritance. So technically, even though they're deceased, they are still going to receive part of that inheritance, which in that situation usually means we have to open or at least deal with the succession of the child who passed away. The concept in the Louisiana law is called representation, and that's when other people step into the rights of someone else to take their inheritance. Now, if there's a last will and testament, there are similar rules that apply. But a lot of times underneath the last will and testament, the will itself will say what happens if somebody passes away before or after the person in question. We have to first look to that will to see what happens. If the will is silent and doesn't have any instructions on that, the general rule in Louisiana law is that if you are leaving something to a child in your will, and that child dies before you, then by automatic operation of law, the grandkids of that child, that person's children, step into their place to inherit from you. So there are default rules in place if you don't provide for it. So why is all this stuff important? Well, when you're trying to figure out heirship in a succession and who's going to have an interest in a property, a lot of times people don't realize that those deceased heirs actually are still in play, and their portion of the estate still has to go to someone. They don't get written out just because they've passed away. So when we're doing an estate, it's very important for us to kind of plot out the family tree, and if there are multiple people who have passed away, get their dates of death as well, and also find out what's happened in their estate, if it's been opened yet or not, or do they have any other assets. That's the only way we can really clear the title to a property when we're dealing with that for a client. So I hope this information helps explaining what happens with deceased heirs who already died by the time you're opening the succession. If you have any other estate questions, give us a call. We'll see if we can help you. If we can't help you, we'll try to point you in the right direction to get you the help that you need. Until next time, take care.